A very good morning to you all from the eNCA Money Desk. Now, working 9 to 5, or is it whenever you're needed? With cell phones glued to us, we always are just a call or a message away from our jobs. But what about those who choose to disconnect from work-related communication outside of working hours completely? What are your legal rights around this? Let's bring in Leila Moosa, who's from Cliffdeck, Hofmeyer, for her insights. Leila, very good morning to you, and thank you very much for your time this morning. Can your employer request or even demand that you be available all the time?
Thanks very much for having me. Good morning. So the starting point, I think, is to look to what our basic conditions of employment say. And there's a general requirement that employers regulate working time of employees with due regard to, among other things, health and safety of the employees and their family responsibility. Then there's a further provision that actually regulates the number of hours, the maximum number of hours that can be worked, for example, per week. And there it's limited to 45 hours, after which it would be overtime worked, and that too is limited to a maximum of 10 hours per week. Now, what's important to note there is that that regulation of the specific number of hours applies only to those employees who earn below the earnings threshold set by the minister, which is currently at around 252,000 Rand per annum. So I think that's the important starting point. And for those who are perhaps managerial employees and who earn above that earnings threshold, we typically see in their contractual arrangements that it says that maybe their core hours are, let's say, 9 to 5, and then beyond that, they may be required to work such hours as may be necessary to fulfill their employment duties.
Can that be stretched, especially if, as you mentioned, you go beyond that threshold?
Yes. So as I said, there needs to be that due cognizance of the health and safety and, of course, family responsibility. But it's really going to depend on the nature of the job. Now, particularly for those employees who earn above that earnings threshold, we can see people being contacted, beyond what would ordinarily be considered working hours, whether it's by clients, customers, or their employer themselves. And this has now been enhanced by the fact that we are sort of always on, because our emails are on our cell phones, we have laptops, we no longer work on desktops, if we remember back to those days. So really, and that's been also amplified by COVID-19 and the work from home, that essentially our workspace can be any space. So we're really seeing an infiltration into those spaces, and it's really for employers to regulate, depending on the nature of their operational requirements, what really is considered reasonable and where they set those boundaries for their employees, to allow the employees to actually understand where they can set those boundaries for themselves.
So if we do set those boundaries, as you've mentioned, in the family sphere as well as the health sphere, and we choose to disconnect from work-related communication, how far are we then protected by the law, or does it depend on the situation that might arise?
Sure. So that's exactly right. It really does depend on the situation. But from a South African perspective, we do not have a particular law that actually deals with the right to disconnect, so to speak, which we may have seen which we are seeing in some international jurisdictions. But we do see these provisions of our basic conditions of employment, which, and as well as provisions of the employee's contract, which will allow them to regulate how they work and what is considered to be reasonable.
And I suppose just as a final thought from you with that, Leila, any recourse for employees who feel that their employer is stepping over the line, what avenues can an employee approach there?
Right. So like I said, there's no particular law other than those that I've mentioned that really deals specifically with this right to disconnect. But if we look to the international sphere, most recently we've actually seen Australia. I'm not an Australian lawyer, but from what I understand it, they're actually regulating when employers should avoid contacting employees and actually saying to employees, look, if this is being breached, these are your avenues for dispute. So I think for South African employers, they they may look to actually regulate from a best practice perspective, well, when do we anticipate in our work environment that people should be able to switch off, so to speak, and in what exceptional circumstances could they be contacted so that employees can actually regulate that for themselves?
Thank you very much for those insights, Leila. And I suppose it goes to one of those things that we've been saying over the last 4 years with COVID. Working more hours doesn't necessarily make you more productive. And so being creative with how we work and we become flexible is something that employers and employees have been working towards. But thank you very much for those insights. That is Leila Moosa from Cliff Decker Hofmeyer joining us this morning for that update in your business. With that, here's a look at your commodities and currencies this hour.